Hi friends, this is Dr. Jetting Yellosa. I am running a YouTube channel called Law Speeches, where in this channel you can find my lectures on legal matters as well as the contemporary, topical, world and national and international affairs. And today we discuss the right to health under the Indian scenario. So, India, we have a sacrosanct document called the Constitution of India, where which is not only a lengthiest document, a bulkiest document, the makers of the Constitution of India has brought the good features from different parts of the world, and they're given a a highest sacrosanct document to us. The number of parts have been there. The part third is a very important part which provides the fundamental rights, right to equality, right to religion, right against exploitation, right of social and cultural rights. So all those rights have been very important rights which pertains to human being have been included. But it is very strange to know that the makers of the constitution has been purposefully avoided the right to health under the constitution of India, under the fundamental rights. Maybe there some mention is there under articles, the part 4, that is under article 38, 39, 41, 42, and 47. Under the directive principle of state policies, the matters pertaining to health has been added. As you know that part third matters have non-justifiable matters. You cannot go to court of law to seek the implementation of such matters which have been enumerated under part 4. Those are only directions state has to follow. In that, the right to health is included, but it is excluded from the fundamental rights where it is a justifiable right, fundamental for our to us. Then we have one wonderful article is there, Article 21. Though it is very small article, but we can write many thousands of books upon the Article 21. That is the article having only few words. That is, no person shall be deprived of life and personal liberty except by due process of the law. Very smallest article in the entire Constitution of India. Even Dr. Bhimrao Ambedkar also opined that if you want to see the heart of the Constitution of India, you go to the Article 21. So this is Article 21 is a heart to the Constitution of India. So life and personal liberties. So life and personal liberty means includes the right to health. Though purposefully the makers of the Constitution of India avoided adding the right to health under the fundamental rights, because at that time there were a lot of debate took place. If we add the as a fundamental right, we don't have such infrastructural facilities. We don't have such resources to provide a compulsory right to everybody. So because of that fact, though it is not there, but under Article 21, indirectly it has been provided. Then the Director Principal of State Policies, as I told you, is having this right to health. Article 38 provides promotion of public health. It's the duty of the state to promote the public health. Then Article 39 mandates the states protection of health of the workers. State has to take special measures for health of the workers. Then Article 41, which provides special provision for the elderly, sick, and the children with regard to their maintaining their health standards. Then Article 42, which protects the health of the infants and their mothers. And Article 47 speaks about primary duty of the state for improvement of the public health. So it is a duty of the state to improve the health of the people at large. But there is no mention. But I told you that it covers under Article 21 of the Constitution of India. It is not my say, but the apex court of the land also stated the same thing. So right to health, no need to worry. Though it is not provided to us as a fundamental right, but it is there under Article 21, inserted into the Article 21 of the Constitution of India. Because as on today, the conditions are, because of the COVID-19, the world is shaken by the epidemic. People of the world has been shocked in state of shockness. It is a duty of the states to protect the lives and limb and liberty of the people. But states have taken measures, whether we have the right or not to go to courts. For that, to understand this, we have to understand some case laws. The case laws, important case laws, I am emphasizing here. One is a Paramananda Khatara versus Union of India. The case is reported in 1995, All India Reporter, SC, and page number 2039. So in this case, Supreme Court has given a wonderful judgment stating that what are the responsibilities of the medical profession towards the patients and how they have to take care of health. So it is a professional duty how they have to discharge. If they are not able to discharge, then they are liable for prosecution. That has been stated by the Supreme Court. In one other case, like Bandhu Mukti Morcha versus Union of India, very far-reaching case, landmark case in the annals of the Indian judicial system, is reported in 1984 Supreme Court, All India Reporter, page number 180. It has stated, court has held that the DPS, Director Principal of State Policies, have persuasive value, duly should be implemented by the states. and the state should take the responsibility of the health of the citizens. Though there is no mentioning of it in the fundamental rights, but I told you, Article 21 is there, under which the state has been obliged to provide the facilities for improvement of the health of the citizens. In one more case, like Consumer Education and Research Center versus Union of India. So in this case, court has crystal clearly opened its mind and stated that Article 21 covers right to health. So it is the duty of the state to take care of every citizen's health. Then in one more case called Ram Lubia case, the state, in this case, the court, Supreme Court, apex court of the land, held that state should take utmost measures for protection of the life of the citizens, health of the citizens. And in one more case, like Pachim Banga Khet Mazdoor Samiti versus State of West Bengal, 1996, SCC, page number 37. Supreme Court has another reiterated its earlier decision that state has to take special measures and also provide adequate medical aid to the public, irrespective of the caste, creed, capacity, status. Common man is entitled for right to health, that is there. But the conditions now, India and world is suffering with COVID-19. You know, India never provided more than 2% of GDP towards the health care. Since independence, whatever governments are coming and going, whether rightist, centrist, whatever parties may be coming, no government is providing more than 2% of the budgetary allocations for the healthcare system. But now we are undergoing very severest health crisis in our country and in the world. To meet that, the Prime Minister, Sri Narendra Modi, has come out with a lockdown idea. And there were for 2 months, the entire country observed the lockdown to mitigate, come out from this coronavirus crisis. Whether the imposition of the lockdown comes under the violation of the Article 21, life and personal liberty. The question came before the court, the Supreme Court. And Supreme Court has stated that it is a conflict of, no doubt, because of the imposition of the lockdown, our personal liberty of going outside or certain rights, right to do the business, right to do the profession, right to do some other things have been curtailed. A conflict has been taking place between the two fundamental rights. But this measure should be adapted. Otherwise, we should not cope up with the situation. So, in tandem, these two things has to be taken note of. And recently, Supreme Court also stated that urged the government to take special measures for the purpose of meeting the conditions in the COVID-19 situation. So recently, Delhi High Court also taken directed the governments to go for testing of more patients who are suffering with the pandemic of COVID-19. Even Telangana High Court, yesterday, it has opined that it has given directions: test, trace, and treat. The principle, 3 T's. It has got angry towards the government of Telangana. Why they are not doing it? It's a comes under the whether comes under the fundamental. The state has the responsibility, though indirect responsibility is there upon the state. If he fails, then the courts are coming and interfering and directing the governments to take special measures to tackle the special problems. Though we have to admit, no doubt about it, that we have the limited resources. We are in the developing stage. We have to look after all the things. But emergency situation requires emergency decisions. So still in our country, the right to life, right to health, life is a fundamental right under Article 21, but right to health is we can say that still at a nascent stage, in beginning stage. Though we have adapted number of international conventions, UDHR of 1948, International Convention on Economic, Social and Cultural Rights, International Convention on the Child Rights, International Convention on the Disabilities. All those conventions have been providing, mandating the signatories of the convention to take care of the health of their subjects. No, we are taking care, no doubt about it. But still we are far away the medical sector, because lesser grants to the medical sector, the burden is more upon the medical practitioners and paramedical staff. So the governments should think, because right to health is a part of the human rights. The government should come out, take special measures to combat the emerging situation. Thank you.